Today we're talking about controversial topics in America. It's going to be a wonderful session. I have three wonderful colleagues here at Georgia Gwinnett College. I will encourage you frequently and often. I know we're going to talk about I'll get there in a second, but please make sure you plug what projects you're working on, plug kind of also what we're working on in the department in general. It's always good to not just, I know we have a bunch of students here as well, kind of talking about the overall, what we're working on. So please don't hesitate to talk about yourself. I'll do some brief introductions. I'm going to set up the talking points. Topic one, talking about the Florida bill, and then topic two, we'll talk about critical race theory. Like I said, we have three real presenters, and I'm going to start here, kind of framing up how this will go in kind of I say rules, but more it's just how are we going to engage in a discussion right now. And for the most part, it's going to be blocks or chunks of time, and I'm going to first concede my time to Dr. Jones here. He will be the first to kind of engage this question, certainly of the Florida bill, i.e. the Don't Say Gay bill, at which point we'll see a follow-up. Certainly if there's any major issues, I can see someone's raising their hand right now, so we're not going to take any immediate questions, but if there are any issues, please let us know in the chat. That said, it'll follow up by Dr. Azaran. He'll give kind of not a rebuttal, but kind of another side of the discussion. In that way, we're going to kind of see, I want to say more of an informal clash, but we're going to see kind of a conversation grow, hopefully organically. I will then drive it back to Dr. Jones, who will be able to speak for a minute or two, and then Amir will have a very brief moment to kind of conclude the conversation. We'll then switch over to Dr. Grant, who will talk about critical race theory. And maybe I should start here as a way of introduction. I will briefly say, sorry, I'm not even introducing my colleagues. I'm getting ahead of myself and flustered here. But certainly Dr. Jones has now been with the GGC department as associate professor, both him and Dr. Azarvan, and also Dr. Grant. Like I said before, wonderful colleagues. Dr. Jones engages in a myriad of civic education, and civic kind of engagement, writing, and on top of that, he's also interested in various human rights conversations today. Dr. Azarvan has a similar interest. He even takes kind of a more holistic approach and even introduces kind of some of the root causes, dealing with not just some of the critical issues that we reflect on today, but also kind of spiritually as well and religious. Some wonderful conversations with him. And then Dr. Grant as well, and deals with kind of American politics, certainly local and state politics, and Georgia politics as well. And doing my research, I also found out, and I hope he talks a little bit about it, about this microfarm, that he has some kind of microfarming association with GGC to help learn about sustainable living, which is amazing, and I'd love to hear more about it. But maybe today is not the day for that. So Dr. Grant, please, when it comes to you, feel free to take the conversation where you want. That said, introducing my colleagues, I won't take up too much of your time because again, my connection issues. I do want to kind of give a brief timeline because it's a fascinating, and even the two topics themselves that we're kind of engaging in right now, talking about the Florida bill and really, as the Florida bill puts in its title, parental rights, but questions about certain vulnerable communities. And on the other side, critical race theory, which is, probably not a familiar term that just rolls off the tongue unless you've been kind of alive the past year. It's not something that we've certainly engaged in the political scene for a very long time. So how kind of do we get these two topics? And I want to kind of put them together in a sense that Florida recently, and while we're talking about the Florida bill, not just passed when we talked about the Florida Rights bill, but also before that in December and moving into January, had a similar kind of traction with a banning kind of the discussion or not allowing discussion of certain racial questions or racial issues within their schooling as well. Almost at the same time, we see kind of comparatively, we see these two during the era here. Kind of how did we get here, very specifically, and the only way I could kind of put it together or think about it is if we actually go back a little bit to 2020, and I'm just going to do a brief timeline, and I say brief, and I apologize again. Where in 2020 we almost see two kind of different points that are almost destined for collision, and one of them is certainly into March. We see the 2020 pandemic reaching kind of, and no pun intended, a fever pitch. talking about kind of going into emergency lockdowns. And at the same time, 2 months later in May, we see kind of this police footage cam of the George Floyd case and his death. And at the same time, these two things happening at the start kind of leads the nation to question, leads us to start questioning a lot of issues. And we see that now in several election cycles. On the pandemic side, we really start questioning about, as schools start shutting down, what kind of involvement will we get with children, what kind of ways do we need to really help them, support them in these difficult times. On the other side, when we saw with the George Floyd case, the nation starts really asking itself, how did we get here? How does this scene happen? More importantly, for critical race theorists, kind of looking at a scene where there were minority officers on scene as well that kind of watched it happen. How do we understand this? How do we deal with this? How do we handle this? Only these two simultaneous, huge questions we see coming down the track. And it all kind of comes to the head in what we saw in the Virginia kind of elections, the gubernatorial race, when Youngkin started to really press for the first time this idea of parental rights. Now, parental rights are nothing new, but certainly as a political discussion or a dividing point, that certainly is new. And on one side, we can see, as McAuliffe, the other candidate in the Virginia gubernatorial race, started to see, well, we need to really empower administrators, school officials, school boards. We can't have parents consistently coming in and constantly criticizing in all areas. And at the same point, we see Youngkin talking about the Loudoun County scandal about sexual assault and the need for parents to be quite involved. And we see this kind of come to a head, and the victory of Youngkin kind of throws this to the forefront of everybody's mind in an off-year election with Virginia, which then leads DeSantis, Florida's Governor DeSantis, to immediately praise Youngkin and start talking about now is the time to fight back. And now we're seeing kind of those two kind of threads come down and translate to legislation. And maybe I've said too much. Hopefully that sets this up for you, Dr. Jones. I'd like to pass the baton here of kind of where are we at? How did, more than how we get here, where are we going, and kind of what does this mean for politics in America?
All right, thank you, Dr. Sprunk. Yeah, I think Dr. Sprunk laid out the background fairly well. Again, the idea of parental rights is nothing new. The name of the Florida Act itself is the Parental Rights in Education Act, and so just the name itself, tells you or signals that, oh well, we're just expanding the role and influence of parents in education. And again, the idea of parental rights is nothing new, but the question is, whose parents, whose rights? So these bills are frequently tailored with a specific segment of the electorate in mind. Again, these kinds of controversies are not necessarily new in American higher education. Political control over school curriculum has been around for a long time. So, but in the context of an election year, and as Dr. Sprunk said, the success that Governor Youngkin had in the Virginia gubernatorial race by making parental rights a big issue, and his opponent Terry McAuliffe, is going to be, I would imagine, is going to show up in a lot of sound bites in Republican ads as we go into the election, portraying Democrats as being, not concerned with parental rights, because he I can't remember his exact quote, but he basically said, we should let the administrators and teachers decide what's best for children. So, and again, that tension has been around for a long time. I want to go over what the Act actually says and highlight what I think are some of the major problems with the Act. So let me got some slides here. So I want to make sure you can see what I'm seeing. So, so you should be able to see my. So can everybody see my slides?
Yes. Yes.
Yes, sir.
Great. Thank you. Again, the official name of the law is the Parental Rights in Education. I'm going to go through some what I consider to be key clauses in the law. So this is the specific language that gave rise to the "Don't Say Gay" acronym or name. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3, or, and that "or" is very important, or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. So there's some potential problems just with that clause. One, it's very vague. Most people would say it's intentionally vague. So what does classroom instruction include? Does that include any discussion in a classroom? If a student says, well, why does Johnny have 2 dads? Are basically teachers supposed to stay mute and say we're not allowed to discuss that? Who are third parties? Is that anybody who other than a student in a classroom? Is it anybody who's not employed by the schools? That include parents, volunteers? Doesn't specify. And even though it says may not occur in kindergarten through 3rd grade, the "or" is very important because that says essentially anywhere in K-12 that is not appropriate or developmentally or age appropriate or developmentally appropriate. Well, what does that mean? Who gets to define what is age appropriate or developmentally appropriate? And that's not specified in the bill. So again, it's very open-ended, very vague language. And again, some would say intentionally so. Another key element, again, in accordance with the rights of parents, school districts will adopt procedures for notifying a student's parent if there is a change in the student services or monitoring related to the student's mental, emotional, or physical health or well-being. What does that mean? It means that essentially if a student goes to a school counselor and talks about any struggles that they're having, and again, this is not limited to LGBTQ plus students, but kind of that's the target, and says, look, I don't want to come out to my parents, or I'm being bullied at school for my gender orientation or sexual orientation. I'm having a hard time coping with this. Well, one interpretation is that, well, the school would need to notify the parents. And of course, that kind of would make students clam up, right? Well, if, why should I go to the school counselor and tell them about my problems if they're going to have to immediately report those to my parents? And I really don't want to talk to my parents about that. And it says, that the fundamental rights of parents to make decisions regarding the upbringing and control of their children. Well, again, we kind of, on the one hand, we take that for granted, but we also know that there are certain things that that young people go through that they may not want to share with their parents. I mean, you can encourage them, right? If you're a school counselor or a mentor to a young person, you can say, well, maybe your parents would be very understanding, maybe you shouldn't try to hide this from your parents. But again, we're talking about in certain socially conservative places, the repercussions for a student coming out or a young person coming out to their parents about their gender identity or their sexual identity, could have some very meaningful and not always positive consequences for that young person. Now, again, the language says it should require school personnel to encourage. So it doesn't necessarily mean report, but we'll talk about another section of the law that school administrators may say, just to be on the safe side, let's report everything. I'll tell you why in a minute. But the problem with this, as I said, this violate some of the rights of children. In particular, the existing ethical standards for the state's own school counseling frameworks says each person has the right to privacy and to expect the counselor-student relationship to comply with all laws, et cetera, pertaining to confidentiality in the school setting. So there's some contradictory language in the law and then what the state's own kind of ethical standards say with respect to at least school counseling. So that's a problem. At the beginning of the school year, each school district should notify parents of each healthcare service offered at their student's school, with the option of the parent to withhold consent or decline any specific service. Also, it says before administering a student well-being questionnaire or health screening form to a student in K through 3, the school district must provide the questionnaire or screening form to the parent and obtain the permission of the parent. So again, problematic. Parents can basically have the right to deny access to services that could benefit their own children. Again, and with respect to some of these questionnaires are designed by professionals, usually by healthcare professionals, psychologists, et cetera. A parent may look at that and say, well, I don't want my student answering that question, so I'm going to withhold my consent. This is all part of a broader reaction to expertise and the role of experts and professionals in whether it's healthcare, science, pandemic control, et cetera. So there's a problem. Parents can withhold services which is if the parent doesn't say no, then that's implying consent. If you're a parent, you know how many times students will bring home forms that you're supposed to sign, and not all parents sign all forms. So again, these questionnaires are important because the school wants to be able to design healthcare and student support services based on students' needs. They don't know what the students' needs are. It's more difficult for them to create those services. Remember I said, even though the law doesn't require parents to, basically tell their students to meet with their parents, it just says encourage. This piece of the law is particularly problematic. If a concern, basically a complaint raised by a parent, is not resolved by the district, a parent may bring an action against the school district. What that means is they can sue the school district, and it's the parent that can do this. And if the parents win in court, the school district has to pay whatever damages are awarded by the court, as well as attorney fees and court costs. So basically, the state has said, we're not going to enforce the law. Parents will enforce the law by raising complaints and civil suits against school districts. What this could mean in practical terms is that the school districts then will say, look, to avoid being sued, we will overinterpret and over-enforce these regulations so that, so we don't have any lawsuits. Which again is going to probably decrease services that are available to students, decrease the flexibility that teachers have in the classroom, and thereby actually diminishing the quality of education that the students receive. Again, By June 30th, 2023, the Department of Education shall review and update as necessary the school counseling framework. I've already referred to that, in accordance with the requirements of this act. The current standards, as they're stated now, says each person has the right to be respected, to be treated with dignity, and to have access to a comprehensive school counseling program that advocates for and affirms all students, regardless of, and I've highlighted, sexual orientation, gender, gender identity, expression, or family type. Well, that seems to be in conflict with the intent of the law, which is to keep those topics out of school altogether. And so, again, that you're basically singling out a subset of students based on sexual orientation, gender, gender identity, etc. And whether those students will be respected or treated with dignity based on this law is an open question. So what are some of the potential consequences? Well, Governor DeSantis has already used this law to attack who he sees as his political opponents, particularly the Walt Disney Corporation. Without going into any detail, the Disney World has a special carve out. So for all intents and purposes, the Disney complex and resorts are their own municipality. They run their own police services, their own sanitation services, their own water treatment services, their own utility services. So they're in many ways, like I say, a municipality in and of themselves. And so Governor DeSantis is basically threatening to take away that special classification, which has been in effect since 1967. But again, he's saying, hey, if you oppose this, watch out. It's likely to have, like many of these laws being passed, including laws, I haven't heard the update on the divisive content bill that was being considered in Georgia, but again, many states are passing these kinds of laws, and very likely will have a chilling effect on teachers and school counselors, particularly in terms of how they not only address questions of sexual and gender orientation, but how they treat the children, how they treat children, or how they treat the children's parents who may be LGBTQ plus individuals. Again, it makes these topics taboo. And so if you are an LGBTQ young person, you know that your very identity is a topic that is frowned upon. So your identity is being singled out as something that should never be discussed in a school setting. That, again, as I mentioned before, these regulations on healthcare and counseling services, I think, violate the privacy of the students. And all of these things together will likely increase the already high incidence of mental illnesses among LGBTQ students. LGBTQ students are more likely to experience depression. They're more likely to experience thoughts of suicide and self-harm than their straight counterparts. This is already a problem, and I think this particular law is going to exacerbate that problem. There's the question of, well, does this law potentially violate the 14th Amendment Equal Protection Clause? Because it is basically designed to single out children, both in terms of their education and in terms of the support services they would receive on the basis of sexual or gender identity. I'm not a lawyer, so don't know how that will be resolved, but I think definitely there are going to be lawsuits and constitutional challenges based on many of the topics that I've already described. So hopefully I haven't gone too far over time, and I'll stop there and listen to our colleague, Dr. Azarlan. Thanks.
All right, thank you, Dr. Jones, and thank you, Dr. Sprunk. And good afternoon to our audience. So my purpose this afternoon is to explain why even the average liberal who considers himself a staunch supporter of LGBT rights should, provided that he thinks consistently, consider supporting the parental rights and education law, otherwise known to critics as the Don't Say Gay law. And although that might sound very far-fetched, consider how a majority of Democratic voters, and not just most registered voters overall, were found to support this law when they were shown its actual language. I think it's fair to say, of course, that the law's strongest supporters hold conservative or traditional values on sex and gender. Reasonably or otherwise, they are concerned that in the absence of laws like this, their right to instill these values in their children would be threatened. There appears to be a very interesting pattern in how critics of this law address this concern. They typically argue that this right is in no way threatened, since teachers can't brainwash their straight and gender conforming kids into being gay or trans. Note, however, that in responding in this way, they are implicitly affirming, or at least they won't dare to publicly deny, that parents do indeed have the right to instill their traditional values in their kids. And I'll refer back to this widely accepted idea, which is central to my argument, as the consensus principle. In support of the view that one's sexual orientation and gender identity are qualities that are inborn or are in some other sense permanent or unchangeable, they might, among other things, cite research on sexual orientation change efforts, otherwise known as gay conversion therapy. They'll cite studies, for instance, reporting that such methods are ineffective or even harmful. And of course, such studies do certainly exist. Now, before I continue, I want to make crystal clear that the question of whether one should or should not seek to change his sexual orientation is completely irrelevant to this discussion. What is relevant, for reasons that I'll soon explain, is whether these methods are effective. So there's a difference between the two. I can lay out effective ways of committing genocide on a people that won't thereby make it morally justifiable. So there's a clear difference here. I just want to make sure that we're on the same page. And as far as efficacy is concerned, the truth is that the scientific evidence is mixed. There is research demonstrating that such therapy can, whether we like it or not, again, that's irrelevant, effectively and safely reduce not just same-sex attraction, but behavior as well. To cite but one example, the author of a longitudinal study published in the Journal of Sex and Marital Therapy found evidence that successful change of sexual orientation occurred for some individuals concurrent with involvement in certain religiously mediated change methods. Even the American Psychological Association, which is by no stretch of the imagination a supporter of this therapy, has acknowledged that there are studies that document that there are people who perceive that they have benefited from it. So how do we reconcile these contradictory findings? For one thing, there are multiple types of this therapy. Some are more questionable than others. So if some studies investigate the effects of one method and other studies examine the effects of another, there's no reason whatsoever to assume that they will yield the same results. Another reasonable theory is that success depends partly on one's willingness to undergo change in a sexual orientation. So if, for instance, you have no desire to change, but your parents are forcing you to seek counseling, success is far less likely, obviously. It's even more obvious that one can change his gender identity. Estimates of detransition rates among adults vary from less than 1% to 8%. A recent British study put the figure at nearly 7%. Of course, that is a very small minority, but even that suffices to demonstrate that it is possible to detransition. It does happen. Now, with respect to those who are most relevant to this discussion, i.e. children, this phenomenon appears to be the norm. In an article published in the Journal of Sex and Marital Therapy, it was noted that every follow-up study of gender-diverse children, without exception, found the same thing. Over puberty, the majority of gender-diverse children cease to want to transition. And I'm not quoting, by the way, from the Heritage Foundation, the Family Research Council, or some other conservative organization, this is a very prominent journal in the field of human sexuality. In short, whether it's desirable or not to do so, it is possible to change by an act of will one's sexual orientation or gender identity. And if it is possible, then it's also possible that one can be persuaded to seek or not to seek to change it. This is where the Florida law comes in. Teachers are acknowledged to be among a child's most important agents of socialization. If some work to directly or indirectly persuade children to live or identify in ways that run counter to the values that their parents wish to instill in them, then they're guilty of violating the consensus principle. The principle which, again, most of us appear to accept, that parents have the right to teach traditional values to their children, even if some people find those values morally repugnant. Now, if you're tempted to deny the consensus principle and insist that a parent does not have the right to raise children with values you personally find objectionable, then consider this. You are not only at odds with the First Amendment's free exercise clause, in which that right is implicitly guaranteed. You have the right, in other words, not only to say that you are, say, a Christian or a Muslim, but you have the right to live as one, to exercise that faith. But also, I would argue that this right is guaranteed under international law as well. For instance, in Article 18 of the International Covenant on Civil and Political Rights, to which the U.S. is a party, we read the following: the states parties to the present covenant undertake to have respect for the liberty of parents to ensure the religious and moral education of their children in conformity with their own convictions. If you respect constitutional and international law and affirm one's right to be, say, a Christian, but deny him the right and religious duty spelled out in verses like Ephesians 6:4, if we're talking about Christians in particular, to raise his children as members of the same faith, then, as blunt as this sounds, you're either a liar or simply confused. Furthermore, laws like this may be necessary to boost confidence in public schools. Since 1973, when Gallup began tracking this, confidence in the public schooling system has plummeted. 36% of American adults had very little to no confidence in public schools back in 73. Just last year, that figure jumped to 67%. It's no coincidence that we've also witnessed a huge surge in homeschooling. Now, teachers tend to be more liberal than the population at large. If they are permitted to discuss sexual orientation and gender identity to 5 to 9-year-old children, I just want to emphasize that again, 5 to 9-year-old children, I can only imagine that this will worsen matters. If only for the sake of saving public schooling, I think we should all, across the ideological spectrum, want to rein in on what many perceive to be social engineering. At this point, I want to address 2 objections to this legislation. I won't be able to cover all, obviously. The first of which is that the language of the law is ambiguous, and Dr. Jones pointed this out pretty extensively. And I admit that I had some of the same concerns. For example, what does age-appropriate or developmentally appropriate material consist of? And reasonably, one might argue that this lack of clarity could lead to unintended consequences. However, and I don't think this will completely allay this fear, I do think it's important to read the relevant provision in its entirety. Once again, because Dr. Jones posted this on a slide. The law says the following: classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3, or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. That last clause, in accordance with state standards, cannot be overlooked. Yes, I do wish that those standards were spelled out in the law itself. So I definitely understand this concern with the ambiguity of the law, the arguable ambiguity of the law at least. However, those standards are there. You can look them up. It's not difficult. The law says that teaching content must be appropriate, not in accordance with one's personal whims, in which case I agree, the law would be implemented in an entirely unpredictable manner. But it is to be appropriate in accordance with existing state standards. And all one must do, again, is to look up those standards. Now, I'm not naive. The average opponent of this law won't become a supporter upon doing this, since those standards are decidedly conservative. And I could give some examples, but they definitely have a conservative nature to it. But Again, I believe that these standards should at least allay one's concerns specifically about the clarity of this legislation. As for the second objection, you might argue that this law contradicts our so-called separation of church and state doctrine. And I put that in quotation marks because you don't find that language anywhere there, but it is derived from the Establishment Clause of the First Amendment. And there are those who would argue that this represents an attempt to legislate morality. In this case, I would ask you two simple questions. So this is kind of a hypothetical discussion with somebody who had raised these issues. First, do you agree with me that racism is immoral? Assuming that you do, and I pray that you do, otherwise shame on you, I then ask if you have confidence that racism is immoral. Supposing that your answer to the latter question is yes, allow me to make very simple points here, two simple points to be exact. First, you cannot scientifically prove that racism is immoral. We know that it's immoral. Our intuition, or to use biblical language, the law inscribed on our hearts tells us that racism is wrong. My second point is that you have faith that racism is immoral. And I want to just really emphasize the word faith in this context. How is this so? After all, I never use the word faith in my line of questioning. The interesting thing about the word confidence is that it's based on two Latin terms, con, which means with, and fide, which means faith. So to be confident in something is to have faith in it. To synthesize my 2 points, you have faith in that which can be scientifically proven. I just want to reiterate that. You have faith in that which can't be scientifically proven, in which case you sound an awful lot like the religious people so often maligned by the left today. The only possible difference is that your faith is not rooted in a belief in a God, as theirs is, but that difference is completely irrelevant, at least from a constitutional standpoint. According to Cornell Law School's Legal Information Institute, the First Amendment's Establishment Clause prohibits the government from unduly preferring non-religion over religion. The truth is, all of us who participate in politics, including those who support parental rights and those who oppose them, are motivated by moral beliefs. We all want to legislate morality. Politics can be defined as a struggle over whose morality gets to be legislated. And to deny the right of some people to participate in the struggle on the grounds that they believe in a God is to unduly prefer non-religion over religion, and that is unconstitutional. Thank you for your time.
All right, if you want to go back to Dr. Jones, you'll have about 2 minutes if you want to discuss any specific points.
Sure, a couple of things. First, I'd like to point out that, or at least my opinion, I don't think that that pre-Parental Rights Act violated the rights of parents to teach the values that they deem appropriate to their children. The fact that students may learn things other than what their parents would like them to learn is particularly at the upper levels. Well, hopefully that's part of what we consider to be critical, teaching critical thinking. It's not instilling in students the preference of a gay lifestyle or the preference of gender change. But simply discussing those topics does not equal instilling, and it by no means, unless a teacher were to say, well, your parents are wrong, and I hope a teacher would not say that, but simply by asking students to consider alternate perspectives, which is what we hope students learn to do, at least by the time they graduate from high school. They can't consider alternate perspectives if those perspectives are forbidden in class. I don't take the First Amendment approach. I'm not seeing this as a way of instilling a particular set of religious beliefs into the law. What concerns me from a constitutional perspective is the singling out of a group, which again, based on a kind of a cursory review of the 14th Amendment, the 14th Amendment is, supposed to prevent. The law should not be used as a way of granting certain rights to one group and then denying those rights to another group. And to me, that's the biggest, constitutional threat here, is the violation of the rights of LGBTQ plus students who have already kind of affirmed that identity, and the rights of their parents or the rights of LGBTQ plus parents. Just as Dr. Ajlavan said, well, a religiously conservative parent has the right to teach their children that homosexuality is a immoral, sinful act. An LGBTQ plus parent has the same right to instill an ethic that says one's sexual orientation, one's gender orientation is not a question of morality. You should be accepted, and you have the right to be accepted and treated with dignity, regardless of how you identify yourself. That, again, speaking of international human rights law, that is the fundamental principle of international human rights, is that each person has the right to be treated with respect and dignity. Again, from that perspective, I think this law violates that basic principle and potentially violates 14th Amendment Equal Protection Clause.
Dr. Arzavan, you want the last word?
Sure. So, I definitely agree with the value of teaching critical thinking in schools. But, just to reiterate, this law applies to children ages 5 through 9. And yes, I understand that appended to that is reference to material that is age or developmentally appropriate. But, if we're referring to the specific age group, we're dealing with a type of student who is very impressionable. And what I'm calling for is not so much to enforce traditional values through the public schooling system, but to enforce neutrality. Because children who go to public school, they spend a large portion of their waking day away from their parents, being frankly indoctrinated in many instances. And it goes well beyond sex and gender. If a teacher was instructing students on homelessness and said, homeless people got to where they are because of their own laziness or their lack of virtue, that would really annoy me, because the teacher is going beyond the moral principles that I want to instill in my children, which of course are not limited to sex and gender, but it would cover how we are to treat people. I would rather teachers limit themselves to the sort of content that is normally taught to these age groups. If, for example, you had a father who was kind of a postmodernist and taught his children that, 2 + 2 doesn't equal 4, it equals 5 or 6 or whatever you want it to be. A teacher in that particular case would be permitted to say, your father is on crack. He is wrong. No, 2 + 2 always equals 4. There's no problem with that. But when we're dealing with values concerning homelessness, racism, sex, gender, and so on, these are things that should be taught exclusively by one's parents. So I'm not saying we should use the schools as an instrument of imposing traditional values, but when it comes to critical thinking, this is something that is best encouraged in later years, in middle, high school, and certainly in college, where unfortunately very little of that is being encouraged. But yeah, that's how I would approach that. So I favor neutrality, not so much kind of treating public schools as parochial schools in a sense, where religious traditional values are imposed upon children. Dr. Jones is absolutely right. There are parents who hold very different values, and I'm not implying that I should that religious parents should impose their values, their beliefs on them.
Well, I can't think of a better point to transition a little bit to Dr. Grant, since both professors now mentioned critical thinking. Let's add another component into this question of not just what's being taught in schools, but at an elementary level or a beginning level, but certainly moving up towards the later stages. Dr. Grant, I won't waste any time. Please, where are we at? How did we get here? Give us some direction.
Okay, Dr. Sprunk, and thank you for the introduction earlier. Well, as we all know, education has always been a political football, especially in the South. We know the history of the United Daughters of the Confederacy and their efforts to influence curriculum in Southern schools as it related to the Civil War and other issues around race. We certainly are familiar with resistance that took place after the Brown versus Board case, where school districts were encouraged to basically desegregate with all deliberate speed. And we know that for many places that was not until the early 1970s. But meanwhile, we had the creation of segregation academies throughout the South. More recently, of course, we know about the Common Core, and which of course came from basically the federal government, or a federal government or nationalist perspective, and how states rebelled against kind of a more of a centralized approach to education. And of course, now we're looking at critical race theory. And even as our own Georgia General Assembly wrapped up yesterday, we have joined the states that want to have some say about, how race is taught in public schools. So that's kind of where we are. So I'm going to just begin by just saying a little bit about the origins and history of critical race theory, and I'll go a little deeper as time permits. But this is something that really began at Harvard by one of Barack Obama's professors at Harvard Law, Derek Bell, where he talked about racism being institutionalized, and I'll say a little more about that. The other thing that we tend to hear a lot about these days, of course, is the 1619 Project that basically began in the New York Times to basically recognize the 400 years of African Americans in the United States, and especially the challenges under slavery and Jim Crow and other kinds of oppression that basically was sanctioned by government as well as the larger society. That has been countered, and the idea that the government was, that the United States was founded basically to, well, I won't say, I will not say to promote white superiority, but basically it was initially argued in 1619 that that was one of the reasons that the nation was founded, to reduce the likelihood that slavery would be eliminated. But I'll say a little more about that again as time permits. A counter view, which we saw during the Trump administration with the 1776 Commission, is basically to argue the opposite, right? And to promote the nation's principles embodied in the seminal documents of the Declaration of Independence and the Constitution and the Bill of Rights. Now, critical race theory generally is not taught pre-K through 12, and even in places like GGC, as I said, it kind of began in law schools, but I will say more about that. But what we have seen, especially in the kind of the post George Floyd tragedy, is that there has been more attention brought to racial issues, and of course 1619 contributed to this, and there have been more discussions about white supremacy and white privilege and what all that means. The politics of it basically has been that Democrats and people who've been more liberal have appreciated this change and greater attention because it does reveal a history that has been ignored. And Americans have learned about white domestic terrorism in the South, places like Tulsa and the coup at Wilmington, how federal government policy excluded agricultural workers and domestic workers in the South who were African American, how the Bill of Rights also limited opportunities to African Americans, and of course the Department of Agriculture in terms of farm loans. So we've learned more about that history, and of course 1619 and others have talked about how these lost opportunities, and 1619 spends a lot of time talking about inheritance and property and citizenship, but just how these loss of opportunities for African Americans basically have influenced the circumstances that we see today. So on the other hand, we have conservatives again basically making the point that while the nation is not perfect and people acknowledge that there has been racism, but again that those founding documents, those seminal documents, have allowed people to and the nation to improve and to address some of these challenges. Then finally, as it relates to schools and the legislation that we've been talking about, that includes, I guess, the previous discussion, but certainly mine, the claim that in schools that white children are being made to feel bad because they are white, and that they are told that they have privilege. So all those things, a discussion about critical race theory needs to cover. Now, I have a slide presentation. I don't know if I should put it up or keep going as we're almost at the hour, 3 o'clock hour. Maybe I should, let me ask for moderator advice here. Should I just keep going, or?
If you have a slide you want to throw up, you're a moderator right now, Dr. Rand, so feel free to just throw it
Okay,
up.
well, let me see if I can get it up. I hate it when it does this. It says it's in use, so I need to. Sorry, guys. Let me see if I can get this. Without losing you. Okay, let's try again. And hopefully this is the right one. I hate this. Okay, well, while it's loading, let me keep moving. So let me begin with the history and origin again. So as I mentioned earlier, Harvard professor Derek Bell introduced this concept of critical race theory in the 1980s. And essentially the point that he's making is that that perhaps we should understand racism as a permanent feature of American life. And also that it is permanent in part because it's systemic. And he makes the point that even though there has been progress, that essentially it hasn't brought about change, and that that racism is still embodied in our systems, in our institutions, and as a result, it continues to be a problem. Now, as I said, this comes out of law, right? This is basically something that comes out of law schools. And I'm going to now refer to Kimberly Crenshaw, another law professor. And she basically says critical race theory essentially forces legal scholars to ask questions. For instance, why does possession of less expensive drugs carry higher jail sentences than more expensive drugs? Could this have something to do with the fact that more people of color are in prison? So again, the emphasis here is looking at the role that the law's role in platforming, facilitating, producing, and insulating racial inequality in our country, ranging from health to wealth to segregation and policing. Now, I think it's finally ready. I'm not sure where I am at it. Can you all see that?
It's loading
Okay,
now.
yeah, okay, it's finally there. Okay, and I think we want to. Okay, so I think I'm going to say a little bit about Kendall Thomas's statement. That basically, in describing critical race theory, he says it focuses on the politics of race. Basically has helped break the stranglehold of racial moralism by challenging the egocentric belief that racism is always about personal fault, private prejudice, and basically individual content. Critical race theory also tells a story about industrialized racial disadvantage and systematic inequality. It highlights structural harms of the colorblind racism. We see it work in laws that don't mention race per se. So again, what's emphasized here is the focus on institutions and structure and systems as opposed to the actions of individuals. So that's an important point. Now let's see, as our time is getting short, I'm going to skip a few other things. And along those same lines, another quote from Dr. Matsuda, another law professor at the University of Hawaii, that basically the problem is not bad people, right? So again, focusing on systemic challenges to racism. And let's see. So, so when we think about racism in the U.S., as we think about critical race theory, again, the focus is, not on individuals, that some want to just basically say that the system is fine, institutions are fine, it's just these bad actors, right? With critical race theory, the racism is seen as more institutionalized and systemic and pervasive. And as Derek Bell suggested, as a result, it has permanence. Now, what do some of the critics say? Well, the critics suggest that a focus on critical race theory can sacrifice academic rigor, and it can basically take the focus off the individual as opposed to putting it on, again, institutions or society, for example. So again, it can diminish the idea of personal responsibility, which is something that's usually brought up when people think about kind of American political culture, the rugged individualism and people pulling themselves up by their own bootstraps. Uh, uh, straps. Well, what else? And again, these critics will say, as opposed to it being systemic, that it is caused basically by bad actors. Now, what has been kind of another interesting response to critical race theory, which initially I was not aware of, but started reading more about it a couple of weeks ago and hearing more about it, is that there's a focus on by some conservatives saying that those who support critical race theory are really trying to are Marxists who are trying to undo America, right? In ways that class could not, and that they're instead using race in an effort to do this. So this is kind of the newer argument, and I think Crenshaw speaks to this in one of my slides. I may not get there because we are getting short on time, but she makes the point that this is often something that conservatives charge when there's an effort to make progress in areas of race in America. If you go back to the 1920s, kind of the age of the new Negro, maybe even a little earlier, when blacks were trying to end segregation, challenge lynching, and these other things, those people who were doing it were certainly doing it because they were trying to overthrow America and they were communists. Same charges against civil rights leaders back in the 1950s and 60s. Even some of the leaders in Black Lives Matter. And whereas some may have said, that they may identify with a socialist point of view, I think for most Americans, especially for African Americans and other people of color who are trying to end oppression against their community, it's usually not as deep as that. It's trying to end police brutality, end segregation, and some of the other means of oppression that people are experiencing. But it's interesting that in some way, shape, or form, this always tends to come up that it's that racial equality is kind of a communist or Marxist plot to overthrow America. So now let's get to the schools as our time is getting short. So as I said earlier, critical race theory is not really taught in schools, but the 1619 Project has been taught. And basically, as I mentioned earlier, it does focus on the 400 years of oppression in America, and and again, the idea that preserving slavery was one of the reasons that the nation was founded. Now, the author has walked that back, right? And basically said that some colonists felt that this was a reason to found the nation, but not necessarily that this was the majority view, right?
We are running a little bit up against it, depending on when this ends. If it ends, Dr. Iverzarn, does this end at 3:15? Do we get cut off or?
Yes, these events normally end at 3:15, like 75 minutes in length normally, unless Dr. Jones has a different opinion. That seems to be my impression.
Okay, well, I am going to move very quickly and take maybe about 2 more minutes and basically speak to the Trump administration's 1776 commission, which was created as a response to the 1619 Project. But there were criticisms, right? I mentioned, included here, a couple of the main contributors. Carol Swain should be familiar to a number of us, as she's a political scientist. But it did not include the American Historical Association. They complained that there was no professional historians as a part of this. And I can mention some of, and I don't think you can see these, but some of the criticisms from Vice President Mike Pence, who says critical race theory is racism. I think I quoted, oh yeah, and Senator Cruz basically compared critical race theory to the Ku Klux Klan, basically. And so. And as we mentioned earlier, a number of state legislatures have passed laws that were an effort to, and I think, again, our good colleague at the beginning talked about the um, Virginia case or election with Youngkin using this as a very important issue to help him get elected. So let me just move to the end as because I basically only have a couple other things, and that is to say that um, there are merits in both on both sides of the argument in terms of uh, not so much that 1619 was the founding of the United States, but many of the principles that began systems and institutions that supported ongoing white supremacy did start there. But the other side of that is, as many conservatives will point out, that what is embodied in those seminal documents, even if they were not applied until the 1970s, at least gave leaders, like Susan Anthony and for women's rights and Dr. King and others, and we can call out a number of different groups. It gave them the ammunition, the justification to say that people are entitled to certain rights in the United States. So again, Constitution, Bill of Rights, Declaration of Independence gave them the moral justification and the political justification and the legal justification to make the argument for equality and inclusion. So with that, and with us having just a couple more minutes, I guess I better stop.
But I'm going to post something to the chat that I was looking up, kind of thinking about what Dr. Eiservan said about kind of should school be value neutral or at least avoid teaching a specific set of values. But that in of itself is a difficult question because there has been for a long time and continues to be what's called character education movement. And I just looked up, some guidelines for character education in K through 3, particularly those grade levels. So I'm going to post that, kind of what it says. One of the categories in character education is respect. And so here's what, again, we might want students in a K through 3 setting to learn with respect to learning the character principle of respect. Treat others the way you want to be treated, be courteous and polite, listen to what other people have to say, don't insult people or make fun of them or call them names, don't bully or pick on others, don't judge before you get to know them. All very good life lessons that I wish adults would pay attention to as well. The reason I bring this up, though, is again, I'm envisioning a situation where a child, may not be that respectful. Again, 5 to 9. Yes, they're probably themselves as children, not at a point where they're convinced what their sexual or gender identity is going to be. There's no question there. But kids do tease, kids do bully, kids do make fun of, so if what happens in the schoolyard when a child is being bullied or picked on because everybody is saying that your parents are gay and gay is bad. Your parents are bad. And so that must mean you're bad. Um, how does a teacher or school personnel person address that situation when they can't even talk about sexual orientation? So we're not talking about teaching students what it means to be gay in K through 3, right? That's not, in many ways, that's a non-issue. I can't remember anywhere in a curriculum where you would be teaching students what it means to be gay at the ages 5 through 9. But when, or a kid calls another kid, well, that's just gay, right? Uh, how do you intervene when you're not supposed to talk about those things? So I see that as problematic. And again, I just see the whole, the negative psychological impact that this is going to have, uh, regardless of what curriculum standards say is age or developmentally appropriate. Um, Again, LGBTQ plus students in high school already have higher incidences of mental health problems. I see this as targeting them, not intentionally, but I think that's how it's going to be implemented. And I'm really, again, aside from the constitutional concerns I have, I'm really concerned about the health and well-being of the LGBTQ plus students who are going to be affected by this bill and its language, and the social, if not the social and emotional implications, regardless of curriculum. So thank you, Dallas, for your question and comment.
All right, how are we doing on time? Sorry, Dr. Azarvan. You said 3:30? Where?
Yeah, I set it to end at 3:45
Oh,
tentatively,
all
and
right.
it
Gotcha.
seems like it's working out because we haven't been booted off this just yet. So
Wonderful. Well, I want to keep that conversation going, and I don't see any hands raised. So I would like to, if I could, kind of pose a question, because I think two great sides have kind of just met here in this conversation. One, Dr. Jones just pointed out, and a real side is mental health. And I think he's referring to, I mean, the Washington Post referred to it, but it's a CDC study showing that specifically, it's true. Vulnerable minorities right now are far more at risk when it comes to several mental health, concerns, especially depression, and where that might lead. And on the other hand, I think Dr. Arzavan brought up a great point, kind of where are the limits of kind of the trust right now in our institutions, specifically what's going on where parents simply just don't trust the institutions to take care or to handle these issues. Both of them are saying the same thing, but how do we kind of meet in the middle right now? I don't know if either Dr. Asva want to field that question, or if hopefully I'm making sense in that question. How do we kind of meet in the middle? Both are kind of concerned. The parents, from the respect they don't trust the institutions, and the institutions saying that we have to handle these incidents when they occur, at the elementary school or etc.
yeah, and tell me if I'm addressing your question, Dr. Sprunk, but um, for me, the guide to go by is the climate, the public opinion climate that we are in. We are a very polarized society, especially on these cultural issues like homosexuality, gender identity, and so on. What Dr. Jones posted, amen to all of that. Treat other people the way you want to be treated, be courteous, be polite, don't bully. All of these things are wonderful, like, at least divorced from specific context, wonderful values. The problem is concrete issues, like what does insulting really look like, what does bullying really look like. We've kind of redefined these terms so broadly, so that if I am to express my freedom of conscience when it comes to sex and gender, it is often construed as bullying, it is construed as evincing a lack of love, it is construed as espousing hatred towards certain people. So while I agree we must be courteous, we must be polite, we must be respectful, we don't agree on when those virtues are being violated, or those principles are being violated in practice. So just going back to your question more directly, You know, if it is the case that our faith in public schooling has plummeted to such an extent, then I think we should be very practical and say, let us maintain neutrality on those particular issues that threaten to divide people. Like those issues that Dr. Jones listed, those principles to go by, that doesn't divide people. I mean, we all have that kind of common moral foundation. We should be courteous, we should be polite. But again, when it comes to sex and gender, I think that if we continue to allow teachers, and I could, you know, provide a number of examples of them going against parental rights. There was an instance in California, for example, and it's not just California, by the way. California is always the state that is brought up in these discussions. But you know, an 11-year-old girl's name and pronouns were changed without her mother's consent. That's disgusting. That should not happen. That totally undermines something that up until fairly recently we took for granted, that parents have the right over these sorts of issues. Since this is threatening to divide the country, we should avoid those kinds of subjects, not, you know, prioritize one over the other, but just to maintain this neutrality. And when those kids reach a certain age, when they enter their middle or high school years, certainly college, that is obviously a very different story. No matter what, they're going to be exposed to different perspectives, and hopefully they'll have the cognitive capacity to evaluate, you know, competing worldviews.